We're going to consider teachers' freedom of expression, what teachers need to know about the law now. Over the years, the courts have ruled that school employees are not always free to express their opinions and beliefs. Employees cannot be disciplined or suffer negative consequences for speaking out on matters of, quote, public concern, end quote. Schools can take action, however, when employees go public with strictly personal concerns. The main U.S. Supreme Court case is Pickering v. Board of Education, which held that freedom of speech, while not absolute, gives employees constitutional protection if they are speaking about issues of a public nature rather than those things about which they have a personal stake. Pickering overturned a school district's decision to fire a teacher for commenting on school expenditures through letters in a local newspaper. For example, if a teacher criticized a building's weak leadership and lacks coordination between grades, it would likely be considered a comment about matters of public interest. If that same teacher complained publicly that she thought she was being unfairly targeted for classroom observations and undesirable assignments, a school district would likely be within their rights to react. But even standing on principles of public concern is not sacrosanct. Employees can still be disciplined based on that expression, like publicly criticizing supervisors, if the district believes that it will impede the employee's ability to perform assigned duties, or the speech will undermine supervisory authority, disrupt the school, or destroy close working relationships. So when confronted with an employee speech case, the court's analysis goes like this. Is the speech a matter of public concern? If not, the case ends and the employee loses. If so, then was the employee's speech outweighed by the state's interest in promoting efficiency in the delivery of educational services? The following rulings illustrate the kinds of cases decided by federal courts on this issue. 1. A teacher cannot be dismissed for wearing a black armband to class to protest the Vietnam War. 2. A teacher can refuse to participate in the flag salute under the First Amendment if she stands silently with her hands by her side. Teachers are in a particularly special position as classroom leaders. The courts have found that teachers are role models, and when operating in their official capacity become, quote, state actors, end quote, essentially an extension of government power. For instance, even though teachers may have a free speech right to join students at a student-arranged meet-me-at-the-pole prayer gathering before school, doing so could be seen as an official endorsement of religion. Furthermore, unlike a college setting, K-12 public school instructors do not have a right of academic freedom. Control of the curriculum, both what is taught and how it is taught, is vested with the Board of Education and the administration. The court wrote in the Pickering case, the state has interests as an employer in regulating the speech of its employees that differ significantly from those it possesses in connection with regulation of the speech of the citizenry in general. Since 1968, there have been cases involving the Pickering decision. One of those was a clarification in 1983, Connick v. Myers. The U.S. Supreme Court clarified the legal consequences of failing to establish the matter at issue was speech as a citizen on a legitimate public concern, and what constitutes a matter of public concern. Most recently, in 2006, Garcetti v. Yavos, the U.S. Supreme Court recognized a significant limitation to the Pickering line of cases, holding that when public employees' speech is part of their official duties, the speech is not protected under the First Amendment. Thus, location and speaking roles are important for teachers. Teachers must consider the forum where they are speaking. There are three kinds of forums. The first, a traditional public forum, for example, a park, a public newspaper, or off school grounds, not associated with a school activity, are safe for teachers to exercise their freedom of speech rights. Non-public forums, which would include being at school, or on a school activity, and significantly in the teacher's lounge, are not safe, and teachers may be disciplined for comments that they make in those places. Finally, limited public forums may or may not be safe because it depends on whose behalf the teacher is speaking. For the most part, if you are speaking as a parent or a concerned citizen, you are safe. But if you are speaking as a teacher and representative of the school district, you may not be safe for statements that you make.